Say welcome to a cozy afternoon at the University of the West Indies. Welcome to the Institute for Gender and Development Studies Public Forum on the Marriage Acts of Trinidad and Tobago. Thank you all for being here. We are going to move swiftly into our program. We have four presenters, four panelists today. Professor Rhoda Reddock, who's Principal of Gender, Social Change and Development, and of course our Deputy Principal here at the University of the West Indies, St. Augustine campus. Ms. Gayatri Pargas, who's an attorney of law and who often works very closely with the Institute. Ms. Nafiza Mohammed, also an attorney at law, former senator, consultant to the Attorney General and chairperson of the San Juan Laventil Regional Corporation. Dr. Jacqueline Sharp, who's president of the Family Association of Trinidad and Tobago, and Ms. Carol Jagannath, who is a student at the University of the West Indies campus and a student who is taking our courses at the Institute for Gender and Development Studies. And we think that because this is an issue that affects young persons, it's helpful to have a younger voice here amongst the other young voices. Eternally young voices. So let me please first welcome Professor Rhoda Reddock for her presentation on the Marriage Acts of Trinidad and Tobago. Welcome, Professor Reddock.
Good afternoon, everyone, and thanks for being here. I'd just like to acknowledge my colleagues from IGDS, Dr. Gabriel Hussain, Ms. Catherine Chan. I'm not sure who else. I see some of our students, graduate students. I'd like to acknowledge my fellow panelists. Good evening, everyone. My presentation today is, we just have between 10 and, if we're lucky, 15 minutes, is entitled The Marriage Acts of Trinidad and Tobago, Gender, Citizenship, and Symbolism. And it is most of what I'm saying is drawn from a larger article, which I wrote and published a few years ago, 2 years ago, entitled Gender, Nation, and the Dilemmas of Citizenship, the Case of the Marriage Acts of Trinidad and Tobago, and it's published in this collection, The Global Empowerment of Women, Responses to Globalization and Politicized Religions. But I won't have time to give that entire presentation. So I just did a much shorter summary, and maybe in the questions and comments, we can go into more details, or you can actually get a copy of the article and read it for yourself. Oh, I have a problem that I can't see the screen, and I don't have it, so I have to change my glasses. Okay, now Trinidad and Tobago currently has 4 marriage acts. And whenever I present this abroad, people often burst into laughter. I notice nobody here even bat an eyelid. And that is because the kinds of diversity of our existence is so commonplace that we take it for granted. And in addition to the 4 marriage acts, we also have the Habitational Relationships Act. So in other words, in our population of 1.3 million, we have 4 pieces of legislation governing those relationships. Now, I just wanted to say something about the four acts. The first one, of course, is the Marriage Act, number 13 of 1945. And this is effectively, and Gayatri Pargas, the lawyer, is coming after and can correct all my legal faux pas. It is effectively both, in my view, the Christian Marriage Act as well as the Civil Marriage Act. Although this is not mentioned in its title, it's called the Marriage Act. This act allows for the solemnization of marriages by Christian marriage officers, usually ministers of religion, or district registrars, usually magistrates. And paragraph 7 states, the president or any person shall duly authorized by him may grant licenses to such persons being ministers of any Christian religion Now, this is the Trinidad and Tobago Marriage Act. Or such authorized person may discretion think fit to be marriage officers, and without assigning any reason for so doing, cancel any such license. Right. Now, in the paper, I go into detail of the provisions of this Marriage Act, the fact that, that there is no fixed age of marriage, but there is an age of consent for both women and men, which is fixed at 18 years, but no minimum age in the Act. And so, therefore, even though the English common law on which it was based has established a minimum age, we haven't. Now, the other characteristic of the Act, a lot of people pay attention to the age of marriage, but I also looked at other aspects. And one of the things about this Act is that mothers are generally not allowed to give permission for marriages for underage daughters. So in fact, the persons, if someone wants to marry a daughter or have a daughter married who's younger than the acceptable age, then the persons who can give permission is the father living, or if the father is dead, then the guardian or guardians of the person that is appointed. In case there is no such guardian, then the mother of such party, if unmarried. And if there is no mother unmarried, then the guardian or guardians of the person appointed by the High Court has authority to give consent to marriage. So I also argue is that even though marriage is so much identified with mothers and women, yet in the Trinidad and Tobago Marriage Act, women, except under extreme circumstances, mothers do not have the authority to give consent to marriages where the people concerned cannot give consent themselves. Next, we have the Muslim Marriage and Divorce Act, number 7 of 1961. And this act is the only one that has divorce in its title. It was last amended in November 1980. And it prohibits the contraction or registration of polygamous marriage. But I think we will deal with that later on. But what is interesting is that at the back of each form, there's a registration form that where people, have to write their names, etc. And in the Muslim sample registration form, there's no column for wife's occupation. So they have husband's occupation, nothing for wife's occupation. Right. These are just quick summaries. Then you have the Hindu Marriage Act of 1945. And in this act, the minimum age of marriage is established at 14 for females, 18 for males. Parental consent is not required for females under age 16. And efforts by the Hindu Women's Organization, anyway, I think I deal with that later on. Again, in this case, in the sample forms, there are differentiations in terms of the wife's occupation is not asked for. And as in other acts, mothers can only give consent when the father, guardian, or guardians are dead or unavailable. And then more recently, you had the Orisha Marriage Act of 1999. And I say that this act, in a way, reflects many of the changes that have taken place in society since the 1930s and 40s, as well as the contemporary revalidation of traditional African religions. The act allows for both priests and priestesses. Mothers or fathers can give consent. Its language is much more gender inclusive, and et cetera, et cetera. The minimum age for females is 16, and for males it is 18, and the sample marriage certificate information includes women's occupation, but not in the same detail as the husband's. And then finally, we have the Cohabitational Relationships Act of 1998, which is the only secular act, in my view, in Trinidad and Tobago. And in this act, for the first time, the country recognized the existence of intimate consensual heterosexual non-legal unions and put forward mechanisms for registration and protection of spouses and partners. I think one thing I should note, and I could be corrected, is that in the Hindu Marriage Act, I don't know if that has been changed, remarriage of widows was not allowed. And therefore, although common law consensual unions have been traditionally perceived as primarily a practice among Afro-Trinidadians, yet among Hindus whose first union has been dissolved, it also became a practice under those circumstances. So I just want to give that background before I give the rest of my presentation. Now, what I argue here is that marriage is seen as something independent between two people. It often has a larger social and political significance, and that religious identities often serve in our society as a proxy for ethnic identities, but they are seen as more legitimate. In other words, it's more legitimate to make religious demands than ethnic or racialized demands. Okay, next. Now, according to the historian Nancy Cott, marriage is the vehicle through which the apparatus of the state can shape the gender order, as well as an institution that sculpts the body politic. It is a mechanism for distributing the responsibilities of citizenship, its perquisites and rights, for legitimating both private and public authority, and for disciplining the production and the reproduction of the people. And by that, it is through marriage that people are supposed to have children, etc. So it's a way of organizing and disciplining these processes. Now, Caribbean social scientists have documented a complicated and contradictory relationship toward formal legal marriage, especially among the African-descended populations. But what we have found from research is that once these systems have been developed, they also become available to a wider sections of the population. So many of the traditional characteristics of family and organizations of intimacy originally associated with Afro-Caribbean people, I want to argue, have now become much more widely practiced, if not as widely accepted. And what scholars have noted is that ordinary people have developed their own ways of understanding these relationships, etc. Next. Now, marriage remains an ideal for many due to its hegemonic acceptance, the hegemonic acceptance of religious ideals, state recognition, etc. Most people who are not married will tell you that the biggest problems they have, for example, are what to put in forms, how to fit into systems and structures, etc. Because even though legislation has been passed, without marriage still as a norm, structures our relationships to state and many institutions. However, I think in our region, a certain flexibility has developed, which is to a large extent accepted, at least more accepted than in other parts of the region. And for example, although illegal, we do know that there are some Muslims who have more than one wife. Next. Now, what I'm arguing is that marriage in our part of the world, especially for Indo-Caribbean peoples, have become a symbol of distinctiveness and difference. And already as early as possibly the 1920s and 30s, the anthropologist Chandra Jayawardena, writing on Guyana, noted that the elaborate Hindu rituals had become an important symbol of difference from the larger society. And so although marriage remains an important rite de passage for women and men in Caribbean populations, already by the 1950s, when marriage ages were much lower, you'll find that already we were seeing among Hindus and Muslims increasing levels of marriage disillusion. In other words, many people got married very young because you had to get married. If you didn't get married, especially in the Indo-Caribbean populations, you were a child. So marriage was a necessary means to adulthood. But many of the early unions may have dissolved for some reason, but many of those people would not remarry. So already research in the 1950s was pointing to an increase in common law unions among people whose first marriage had dissolved, and usually those were marriages at earlier ages. Now, what is the reality of marriage in Trinidad and Tobago? According to the 2000 census, 8% of women 15 years and over were living in married unions. 30% had never had a husband or common law partner, while 10.2% lived in common law unions. The rest were no longer in unions or were no longer in a relationship, a union or a visiting union. Now, this is important because when you ask why is this marriage age, these marriage laws, these marriage matters so important, it's important to see the proportion of the population that in fact are married and of women that are married, which suggests to me that its significance is much more symbolic than actually real. Next. Now, yet we have 4 Marriage Acts, and these are the 4 Marriage Acts and the Cohabitational Relationships Act. Next. Now, the existence of these Marriage Acts, I argue, reflects a continuous process by the state to respond to ethnic, cultural, and religious demands for citizenship based on the recognition of difference. And in my paper, I argue that this is only one way in which the state has responses. There's also the public holidays. There's also what I call the politics of difference, or the multicultural politics, which has characterized our society long before the government declared multiculturalism as a national position. I think that from very early, Trinidad and Tobago had already developed, become a multicultural society. Although the difference between being multicultural and multiculturalism as a doctrine is something we may want to explore further. It also reflects the ways in which group demands for recognition often have specific implications for women. So many of the groups who were demanding, yes, we want these marriage acts, or yes, we want to keep these bills because we are different, we have our own culture. What is the hidden subtext is what is the situation of women in those particular groups, and why it is that most of these marks of distinctions are often marks engraved on women's bodies. So the first 3 acts continue to exist today in that essentially patriarchal form, despite the fact that other legislation was passed since the late 1970s, and 1975 was International Women's Year, and after that there was a lot of change in legislation that introduced greater levels of equality between women and men and strengthened child protection. Next. So in this context, therefore, as I said before, the acts are primarily symbolic, and the result is a change in the age of marriage for women in the Muslim Marriage and Divorce Act and the Hindu Act, despite the calls of the Committee on the Elimination of Discrimination of Women in 2002, suggests that there is something deeper besides simply wanting to keep marriage at those young ages. Next. So, okay, we can move on. We can move on. Right, these are the details, the age difference in each one. Right, next. Now, in the shadow report to the Commission on the Rights of the Child of 2005, and what happens, the government does a report, and then the NGOs or activists do a shadow report. The Trinidad and Tobago Coalition on the Rights of the Child noted that all 4 Marriage Acts violated the Convention on the Rights of the Child, as well as the Convention on the Elimination of Discrimination Against Women, conventions that have been ratified by the government of Trinidad and Tobago. And efforts by the Hindu Women's Organization in the 1990s to increase the legal age for Hindu women resulted in the person who made that call being ridiculed and actually demonized on the front page of the BOM at that time, and therefore, after that, those efforts failed. Next. The 3 of the acts have been subject to changes and amendments over the years, but although they have been superseded by more recent legislation and change, the age in the Marriage Acts continue. They continue also to have certain provisions that conflict with new legislation, again suggesting that they are of great symbolic as opposed to real significance. Next. Right. The thing is that most of these religious leaders are male. They are not the one who have to be married at 12 and 13. And despite the fact that few child marriages actually occur, there continues to be efforts to preserve this. So I'm suggesting that they represent distinct axes of patriarchal power and control along these religious and ethnic lines. Next. Conclusions. Marriage in many ways represents boundaries between the public and the private, and the Marriage Acts are one way in which Trinidad and Tobago has sought to manage its diversity. And where the marriage regime does not provide women with full and equal membership in our community, it diminishes their citizenship in other communities. In other words, that if as members of a religious community, women's rights are diminished, then women's rights are also diminished in relation to their membership of other communities, that is, as citizens of Trinidad and Tobago, as members of other groups, etc. Any more? Next. Yeah, women, men, and progressive social movements need, therefore, to understand the complexities of intersectionality. That's the ways in which race, ethnicity, class, religion, and all intersect to negotiate between the competing communities of belonging and citizenship. In other words, women are members of ethnic groups, they're members of religious groups, they might be members of feminist organizations, they're members of citizens, and they have to balance their membership because in each space, different things may be demanded of them.